Hi, my name's Russ Weninger. I'm a lawyer with Weninger John. In most cases, Alberta law recognizes the principle of testamentary freedom, which is the idea that a person doing a will should be able to leave their estate to anyone they want, and that such a person should also be able to exclude from their will anyone that they want. However, the principle of testamentary freedom isn't absolute, and there are a few different ways that a will can be challenged. You can only will to others what you own. That may seem like an obvious statement, but failure to abide by that principle is a common mistake. For example, a spouse may have a matrimonial property entitlement to half of a testator, in other words, a will writer's assets. If a will doesn't recognize the matrimonial property entitlements of a surviving spouse, it may be challenged. Also, if property is held jointly with another person, you can't just will, quote unquote, your share of the property in question to a third party. With joint ownership, there's a right of survivorship, which attaches to the person who outlives the other joint owner. The survivor automatically, and with very few exceptions, becomes the sole owner of the property upon the death of the other joint owner. Another example of people running afoul of this rule is when corporate assets are incorrectly dealt with in wills. If an asset is owned by a corporation, for example, a family farm, but an individual who has shares in that corporation attempts to dispose of that asset, the farm in this example, not the shares of the corporation, and they attempt to do that through the will, then a court will consider that part of the will to be invalid. In Alberta, a will can be challenged if it doesn't provide adequate support for a surviving spouse or adult interdependent partner, otherwise known as colloquially known as a common law partner, or if it doesn't adequately provide for dependent children. In some cases, dependent grandchildren may even be entitled to support. If a testator was under undue influence at the time they did a will, the will may be challenged on that basis. For example, if an elderly parent is coerced into making certain gifts to certain children, the resulting will may be challenged if there is sufficient evidence of that coercion. A person doing a will must have a certain degree of mental competence. If there is reason to believe that a will has been done while a person lacked capacity, the will can be challenged on that basis. In some cases, undue influence and lack of capacity go hand in hand. Sometimes a will can be challenged because it doesn't comply with certain formal requirements. Also, if there are different interpretations for a provision in a will, it's possible that this could lead to a legal challenge of the will. If you have any questions or comments, feel free to leave them in the comment section. Thank you for watching.